Joint trust or separate living trust. A joint trust is a lot simpler, costs less, easier to manage when one spouse dies, and also fosters a sense of togetherness and unity. So why would a married couple forego that for the more costly and cumbersome separate trusts? That's what we're going to find out in this video. First off, if you're in a blended marriage or in a second marriage, does it automatically mean separate trusts? No, it does not. It's not whether your children are shared together or from previous relationships. It's not whether you're in your second, third, fourth marriage. What matters more is whether the two of you are truly on the same page about your estate plan. In fact, you could have a couple in their first and only marriage sharing all their children, but they have different ideas about their asset distribution, separate trusts. So I want to present a few questions that you can discuss with your partner to help you decide what's right for you, a joint trust or separate trusts. Question number 1, are your assets mostly jointly owned or already separated? Example, you guys got together later in life, already having accumulated your separate set of assets. They're already separate. Another example is if you have a prenup going into the marriage. A prenup is essentially about separation of assets. And a third example is if you inherited a significant asset from your parents, and your desire is to keep your assets separate and avoid accidental commingling. Question number 2. Is one of you a lot wealthier than the other? So last week, Taylor Swift announced her engagement to Travis Kelce, right? Now, he's a rich guy. $90 million is his net worth. But Taylor Swift has $1.6 billion. That's a few more zeros, right? These two wealth levels are going to have very different estate planning strategies. So it's not always because you're not willing to share, but it's just that when you have very different estate planning strategies, it's very difficult to mangle it all into one plan. You're going to need 2 plans. Question number 3, do you have very different beneficiaries? I chose that word intentionally. I didn't say different kids because there are many blended families with children from prior relationships, but they've been married a long time and the parents feel the same emotions and closeness to all the children and stepchildren. I don't consider that different beneficiaries because they'll be treated alike. Different beneficiaries would be, say, you marry later in life and your spouse's children are grown adults, so you don't have much of a relationship with them, vice versa. Or you want to pass your wealth down to your children equally, but your husband wants to share his wealth with his parents, his siblings, his longtime nanny, charities, and you both can't come to an agreement, then you might need separate trusts. You may ask me, can't you specify all that in a joint trust? The more sophisticated joint trust can do that through subtrusts such as marital trust or bypass trust, but the simpler joint trusts where everything passes to the surviving spouse, the danger is that the surviving spouse would then change the terms of the trust after the first spouse dies and overrule the wishes and desires of the first spouse. So a more ironclad vehicle to make sure that your assets are only going to the beneficiaries you intend for and that your spouse cannot overrule that is to use separate trusts. Question number 4, do you and your spouse have different timelines? Let me give you an example. Michael Douglas's second wife, Catherine Zeta-Jones, is only 3 years older than Mike's eldest son. If they did a joint trust, then Mike's children will have to wait for both Mike and Catherine to pass away before they see any inheritance. But they're so close in age that his son could predecease his wife, in which case they wouldn't see a penny of their inheritance. So in a case like that, it might make sense for Michael Douglas to set up a separate trust with its own separate payout schedule. That allows his children to get their inheritance without waiting for his much younger wife to pass away. Question number 5. Can you both agree on the same person to appoint to be your trustee, the same person for your executor, your guardian? If you insist on your sister being your successor trustee and your husband insists on his brother being the successor trustee, and you both can't come to an agreement, you're going to need separate trusts. Because in a joint trust, there can only be one set of guardians, trustees, executors. The last question I'm going to give you is not an easy one. It really requires an honest reflection. Does your spouse present a liability threat to your asset? Example, perhaps your spouse inherited a rental property from his parents, which is run down, and anytime now the tenant could fall in the bathroom and sue you. Or your spouse is a surgeon doing high-risk surgeries day in and day out. It's just a matter of time and chance before a lawsuit crops up. Or perhaps your spouse is struggling with a gambling habit that could expose your asset to a lot of risk. In that case, separate trust could protect your assets from your spouse's creditors, lawsuits, or even scammers who are trying to target your surviving spouse. If you answer yes to even just one of these questions, you might want to consider separate trusts. You can see that, right, that estate planning is more than just drafting documents. It's about life, family, and truly understanding your partner's fears, concerns, values, goals, and the legacy both of you want to leave behind. These conversations are not easy conversations, but the best time to have them is now. The worst thing you can do is to not do anything, and then the courts will be making these decisions for you.